Please be seated. The court is now back in session. Following the OCP submissions and the parties' responses, the Chamber now issues oral rulings on a number of the parties' requests. The full reasons for these decisions shall be contained in the decision on objections to the admissibility of witness, victim, and civil party statements and Case 001 transcripts proposed by the co-prosecutors and civil party lead co-lawyers to be issued shortly, and the final decision on witnesses. Now, on the co-prosecutor's request that the trial chamber hear additional two poetry witnesses, on 19 July 2013, the co-prosecutors requested the chamber hear the testimony of two additional witnesses relating to dual poetry, namely TCW 644 and a new civil party in Case 004. The Nuanchi defense do not object to the OCP request and further request the chamber to summons TCW 802, TCW 803, and Rob Lemkin. The chamber considers that the evidence of TCW 644, TCW 802, TCW 803, and the new civil party would be repetitive of other evidence and not conducive to ascertaining the truth. These requests are therefore denied. The request to summons Rob Lemkin is addressed in a separate decision which will be issued very shortly. On OCP request to reconsider decision not to recall civil party So Sarin, that is document E293/1. The chamber now addresses the co-prosecutor's request to reconsider its decision not to recall civil party So Sarin. Even if considered a fresh application, the co-prosecutors do not allege any new circumstances, nor is the trial chamber satisfied that the provisions of Internal Rule 35 have been met. The OCP request, that is document E293/1, is therefore rejected. Now, on Nuon Chi's request to summons witnesses in respect of alleged policy of targeting Khmer Republic officials, which is a courtesy copy, the Nuon Chi defense requests the chamber to summons more than 100 new witnesses who made statements concerning the targeting of Khmer Republic officials. It repeats and elaborates upon previous submissions concerning the admission, absent the opportunity for confrontation, of statements going through important or central issues in the prosecution case. The Chamber considers that the defense fails to satisfy the requirements of reasonable diligence in discovering and proposing the new witnesses, pursuant to Internal Rule 87.4. Further, with respect to the OCP request to respond to this motion, the Chamber considers that issues regarding to the admissibility and probative value of witness statements have been thoroughly briefed, and it will shortly issue a decision on this topic. Any future motions on these issues will be considered repetitive and not be accepted for filing. The oral request is rejected, with more detailed reasons to follow in writing. Now, on Khieu Samphan's defense request for information regarding Nu Muk. The Chamber first notes that the Witness and Expert Support Unit is presumed to exercise its functions scrupulously and impartially. The parties had an opportunity to explore issues regarding contacts with Visu during the questioning of the witness. In addition, the trial chamber has informally received the relevant information from Visu and therefore concludes that an investigation in accordance with Rule 35 is not warranted. The chamber nonetheless directs Visu to provide this information in a formal report to the chamber within 2 weeks. I turn now to the co-prosecutor's request, both oral and contained in document E-288/4/1, with respect to the respective accused refusal to testify. The Chamber considers that the warnings made to all accused on 18 April 2012 and reaffirmed on 16 July 2013 adequately address the underlying substance of the co-prosecutor's request. The 18 April 2012 warning expressed that the relevant international jurisprudence indicates that adverse inferences from selective decisions to remain silent may be drawn. The trial chamber thus considers that these requests have been answered already. The co-prosecutors additionally request to state in court, in the presence of the accused, topics and facts on which they would have questioned them. The Chamber does not consider that this will be necessary. The co-prosecutors will have the opportunity to indicate, as part of their closing briefs, those points on which they are requesting the Chamber to draw adverse inferences. Next, the Chamber will address the Nunji's defense request to admit new documents, summons Rob Lemkin, and initiate an investigation. The Chamber will file its decision today or tomorrow, rejecting this application in its entirety for reasons set out therein. Turning to the status of other decisions, the Trial Chamber will issue 2 decisions in the near future. That is, the decision on objections to the admissibility of witness, victim, and civil party statements and Case 001 transcripts as proposed by the co-prosecutors and civil party lead co-lawyers, and the 3rd decision on objections to documents proposed for admission before the Chamber. Both of these decisions will contain annexes. All documents that are admitted as a result of these decisions will be accorded an E3 number. Finally, the Chamber would like to address the subject of scheduling from this point forward. In its 2nd severance decision, that is document E284, the Trial Chamber determined the extent of the facts it would consider in Case 002/01. That decision was appealed by the co-prosecutors and Nuon Chea. Pending the appeal, and in order to avoid any prejudice to the parties, the Trial Chamber will not therefore announce that hearing on evidence in Case 002/01 is formally concluded until the Supreme Court Chamber decision is issued. Pending the decision of the Supreme Court Chamber, which will provide further guidance in this respect, the Trial Chamber announces, however, that its tentative schedule is as follows. Closing briefs are to be submitted by 12 September. In the first instance, in any of the ECCC languages, with translations to follow. Closing statements will be held starting 9 October and concluding 22 October, including Fridays. The Trial Chamber has chosen 9 October as a start date in view of scheduling challenges during a month containing many holidays. In accordance with the decisions of the Supreme Court Chamber, the Trial Chamber will formally confirm or amend its schedule when the appellate decision is delivered. For the same reasons, the Trial Chamber will not deliver its final decision on witnesses, experts, and civil parties to be heard in Case 002/01, which will now be included in its verdict, rather than be issued separately ahead of time. The Chamber notes that the parties have already been provided courtesy copies of the annexes to that decision, and that the information contained in those annexes has not changed. Finally, With respect to the closing briefs, the Chamber is according each party an additional 25 pages to respond to any additional evidence or documents put before the trial chamber pursuant to the Chamber's final evidentiary decisions. The co-prosecutors therefore now have 225 pages for their closing brief. The accused each have a limit of 125 pages, and the civil parties have 105 pages, excluding submissions on reparations. This concludes the oral rulings of the Chamber. The Chamber thanks the parties for their assistance and cooperation in these matters. And the hearing today has come to an adjournment. The Chamber will adjourn now, and it will resume on the 9th October 2013, commencing from 9 a.m. President, the floor is not opened for parties. Please be seated. And security guards, you are instructed to take the two accused back to the detention facility. And the trial chamber will issue its order to bring them to the courtroom in the appropriate time. The court is now adjourned.
សូមអញ្ជើញក្រោកឈរ